I'm attorney Kenneth M. Phillips. I'm the author of Dog Bite Law. I'm the only lawyer in the entire United States who has done nothing but represent dog bite victims since the 1990s. I'm here to discuss an important case that just came down from the highest court in New York, Flanders versus Goodfellow. On April 17, 2025, the highest court in New York issued a new ruling in a case called Flanders versus Goodfellow that has national significance for dog owners and dog bite victims. New Yorkers who are bitten by a dog can now sue for negligence where they couldn't before, and dog bite victims in states that have bad negligence laws now have a better chance because of the Flanders case. So I want to get into the three rulings of the Flanders case, but before I do, we have to take a look at the background, which is the case that Flanders reversed. This was a case that was in New York 20 years previously. The name of the case was Bard versus Jahnke. And the ruling in that case was that the owner of a domestic animal could not be held responsible for failing to prevent it from hurting somebody or hurting property. The bottom line was there was no such thing as negligence when it came to a dog or a cat or, in the Bard case, a bull. A bull. What happened to Mr. Bard was that he took a job as a carpenter in a cow barn, and they didn't warn him that that there was a bull that had access to the barn, and they didn't do anything to keep the bull out of the barn while he was in there working. So what happened was he's in there working, he's surprised by the bull attacks him, and he's seriously injured. He had fractured ribs, he had a lacerated liver, and he exacerbated a cervical spine injury. So he was badly hurt, and he sued for compensation under the doctrine of negligence. He couldn't prove that the bull had ever done anything like this before, but what he could prove was it's a bull in the barn, a breeding bull, and he's a stranger to the barn. The bull didn't know him, and that was a dangerous situation that he deserved protection from. So that case, he lost it at various levels, and it went to the New York Supreme Court, which is called the Court of Appeals in New York, and I'll keep on calling it the Court of Appeals. The Court of Appeals ruled that there was no such thing as negligence when it came to a domestic animal, that you always had to prove the elements of what's called the one bite rule. The one bite rule is also known as the one free bite rule, and what it says is that an animal, a domestic animal, basically gets one free bite or one incident where it proves to any reasonable person that it wants to bite or hurt a person in some other way. So the court said the one bite rule was the only way in New York that you could recover for negligence. There was no such thing as the general negligence that all the other states were following to one extent or another. So no such thing as dog owner negligence. And that was the way things were from the time of that case, which was 2006, all the way up to 2025. 20 years later, April 17th, 2025, the court admitted it made a mistake. And the name of the case where the court made that admission is Flanders versus Goodfellow. The court looked at a similar situation and reversed itself. What happened in the Flanders case involved a dog and a postal carrier. Rebecca Flanders was delivering a package as a postal carrier to the home of Stephen and Michelle Goodfellow. And there was no mailbox, so she had to knock on the door, and Stephen Goodfellow opened it, and she was handing him the package, and they were talking about the fact that they needed to have a mailbox in the future. And suddenly the dog belonging to the Goodfellows came rushing outside and attacked Miss Flanders and inflicted serious injuries on her. She suffered a serious shoulder injury that required multiple surgeries and has left her with scarring. She sued for compensation, and she based this on the fact that the dog previously had tried to bite other mailmen through the window. I mean, it had thrown itself up against the window, slobbered on the window, trying to bite through the window. And two other male men testified that this was pretty horrible. The dog looked like it was a dangerous dog. And if the Goodfellows were home when this happened, they had to know that the dog had this desire to bite people. So her case was based on both the one-bite rule and the doctrine of negligence. Now, let me explain what those are. The one-bite rule is based on the animal and the harm or the threat of harm that the animal actually showed in the past. While the negligence doctrine focuses on a person's unreasonable failure to prevent the animal from doing harm in the future. So it's a question of the one-bite rule looks to the past, and the negligence doctrine looks to the future and says, you should have known better. You should have prevented this from happening. So remember also that the Bard case had said that there was no such thing as negligence when it came to a domestic animal, meaning a dog, among other things. So what happened was when the Goodfellows responded to the lawsuit, they brought a motion for summary judgment. This means judgment without a trial. Their motion was based on the Bard case. They said that, first, their dog had never actually attacked anybody else, and second, they weren't aware that the dog had tried biting anybody through the window. But even if they were negligent, the Bard case excused their negligence because there was no such thing as negligence when it came to a domestic animal. The case was originally thrown out by the lower court, and then it went on appeal, and the intermediate court also threw the case out, and then it hit the high court in New York, the Court of Appeals. The court made three rulings. First, it said that the dog's prior behavior definitely did indicate that it wanted to bite people, and therefore, the requirements of the one-bite rule were satisfied. So in other words, there was enough evidence for a victory based on just the one-bite rule. But the court didn't stop there. It made a second ruling, very important for the people of New York, which is that they decided to reverse the Bard case. They said, now we're changing our mind. We never should have ruled that way in the Bard case. They said the Goodfellows could be sued for negligence because the threatening behavior that was indicated by the dog really did tip off the Goodfellows that they should take precautionary measures. So the court said there was enough evidence here for negligence, and a negligence case is a good case. The third ruling of the court is the one that is of interest, I think, nationally. And I'm going to get to that in a second. They said that Ms. Flanders could base her lawsuit on both the one-bite rule and the negligence doctrine at the same time because those two theories are different. And that's a really important ruling. So to sum up to here, the Flanders case is significant to New Yorkers because it says that there is such a thing as negligence with regard to a domestic animal. In other words, for me, who does dog bite cases, it said that there is such a thing as negligence when it comes to dogs. This was a right, incidentally, that the residents of almost every other state in the USA have always had. So New York came more in line with the rest of the country. But it does not give New Yorkers the same rights that most Americans have. New York still remains behind a majority of the states because a majority of the states have what's called statutory liability. This is a form of liability that's based on a statute, and the statute basically says that if you own a dog and the dog bites somebody, you are liable for that. You have to pay compensation for that. This is something that many of us who do these cases refer to as almost strict liability because it allows victims to recover compensation without having to prove the dog's past behavior or the owner's negligence, but it's not like it is strict liability because there are still defenses to it. For example, if you're trespassing and you get bit by the dog, you can't sue under a dog bite statute. If you provoke the dog in some way by hitting it, by abusing it, you usually cannot win under the dog bite statute. But the dog bite statutes are very important because you don't have to point the finger at the owner of the dog. So this is vital in a case where the owner of the dog is a friend, a neighbor, or a relative, a family member. Let me move on to the national importance of the Flanders case. The Flanders case has national significance because of that third ruling, the holding that negligence and the one-bite rule are entirely separate causes of action. Many state courts and legislatures have mistakenly, over the years, treated these two doctrines as being the same. For example, here's a quote from a case in Alabama. That's a key case. Here's the quote. "It is well settled in Alabama that the owner of a domestic animal is not liable for an injury caused by the animal unless it's shown that the owner had previous knowledge of the animal's dangerous or mischievous propensities." Okay, that's the Williams versus Hill case, for those of you who are attorneys. Dangerous or mischievous propensities, that's the requirement of the one-bite doctrine, not the negligence doctrine. Here's Vermont. In Vermont, the court stated, quote, "The question in each case is whether the dog's past behavior has been such as to require a person of reasonable prudence to foresee harm to the person or property of others." Again, this is based on the dog's past behavior. That's the one-bite rule. Similar court cases exist in North Dakota, Ohio, Georgia, and other states that combine the one-bite requirements and negligence requirements and make a dog bite victim prove what amounts to both types of cases in one lawsuit. But allowing a vicious dog to bite someone is one thing, while preventing a non-vicious dog from biting them is another. That's the distinction. Let me give you an example of this to make it really concrete. If a dog owner has a pit bull and he brings the pit bull to a daycare center and the dog mauls a toddler, the dog owner in a one-bite state, if that dog had never bitten anybody before, in a one-bite state, the dog owner would not be held liable, even though they did something so stupid. In a negligence state, the sheer stupidity and recklessness of bringing a pit bull to a daycare center would be enough to make the dog owner liable. The liability is based on the stupidity, the recklessness, the failure to see that that's a dangerous situation, that it's a setup for an accident. So, okay, I'm going to try to put it in other words to make it clearer. The one-bite rule is based on the animal and the harm that the animal caused in the past, while the negligence doctrine focuses on a person's unreasonable failure to prevent what amounts to a foreseeable accident in the future. So in Flanders versus Goodfellow, the Court of Appeals looked at the law throughout the entire United States and concluded that the one-bite rule is about one thing and the negligence doctrine is about something else. And for that reason, the court said that Miss Flanders and any other victim could sue defendants on either the one-bite doctrine or the negligence doctrine. This is real important for judges and lawmakers and attorneys who handle dog bite cases, because even though the Flanders case is a New York case, it's still persuasive authority throughout the rest of the country that dog bite liability does not depend on proof that the dog previously bit somebody or acted like it wanted to bite somebody. All that's required for liability in a negligence case is that the accident was foreseeable and the defendant unreasonably failed to take measures to prevent the accident from happening. So this is why I say that the Flanders case has the potential to reform dog bite laws in a number of states and improve dog bite law throughout the country. It was a landmark blockbuster case for New Yorkers, and it's important for everybody else.